Welcome to the second installment of our 2016 OSHA Webinar Series. Today you will be learning about the General Duty Clause from two very qualified men, Bugby & Kunkel's Certified Occupational Safety Specialist and Workers' Compensation Specialist, Carl Habekost, and Certified Environmental Trainer, Certified Safety Professional, and Certified Hazardous Material Manager, Donald Elswick. Our special guest co-presenter today, Mr. Elswick, is currently employed as the EHSS manager for a worldwide sugar refiner. Previously, he has been employed in the chemical industry and high-speed manufacturing in similar positions. Commander Elswick has also served as a Medical Service Corps officer in the U.S. Navy. He is a veteran of Operation Iraqi Freedom, and he is set to retire from the U.S. Navy in July of this year. Mr. Habekost, meanwhile, served as a staff hearing officer of the Ohio Industrial Commission from 1994 through 2005, where he decided a broad range of disputed workers' compensation claims. His in-depth occupational safety training equips him to assist employers with safety issues that arise in connection with OSHA, VSSR, and intentional torts. Mr. Habekost has also earned an OSHA 30-hour certification in general industry and construction.
Thank you, Carrie. You'll note that Don Elswick is no longer in the chemical industry. He now works for the sugar industry. He is so sweet that the sugar industry sought him out for his sweetness, but also for a little bit of his safety knowledge. I always like to begin any safety presentation with granting the audience permission to establish your own reality. Yes, indeed, you are free to define a safe workplace free of recognized hazards. If you don't take advantage of this, then you know what's going to happen. The federal government's going to come in through OSHA, and they're going to define your reality. So we're going to talk today about some general safety principles, primarily focused on the General Duty Clause. Our agenda today, we're going to talk about the General Duty Clause. We're going to review the history of the General Duty Clause, how it is used by OSHA. We will then focus in more detail on the legal elements involved in the General Duty Clause citation, how OSHA approaches the employer's broad duty to provide a workplace free of recognized hazards. And we're going to review in detail some of the definitions of these important concepts. Then we're going to review some actual OSHA citations that have been issued recently involving the General Duty Clause. Finally, we will discuss best practices for your company to improve safety in the workplace, comply with requirements of the General Duty Clause, save some money, and most importantly, protecting your employees. So, why this catch-all provision? What is this General Duty Clause you've heard so much about? What does it say? Well, it's found in Section 5A of the Occupational Safety and Health Act. It's on your screen. The primary words that you'll need to focus on and that we're going to talk about is recognized hazards, physical harm, and employees. So basically, each employer shall furnish to each of his employees an employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. You know, I love this first quote so much, I just had to include it. The 1970 Occupational Safety and Health Act was created to, quote, assure, as far as possible, every working man and woman in the nation safe and healthful working conditions, and to preserve our human resources, close quote. Preserve our what? Our human resources. Yes, there was a time when employees were actually valued by the federal government. And here it is. This is a perfect statement as to the intent and purpose of the Occupational Safety and Health Act. This significant piece of legislation put two obligations on employers, and they're really quite opposite of each other. One obligation is that employers must comply with specific regulations and specific standards depending on job activity and type of employment. And the other one is this one little single line sentence that I just read to you, the general duty clause. Generally, you must provide a workplace free of recognized hazards. In other words, an employer must abate recognized hazards. Now, just before we move to the next slide, you have to realize there are hundreds, perhaps even over 1,000 regulations that are very specific that an employer has to comply with. Then we have the one general duty clause that we're going to talk about today. OSHA is beginning to use the general duty clause more and more. Mr. Elswick's going to talk to you about it a little bit further, but OSHA is using the general duty clause in workplace violence issues, ergonomics. You might remember Walmart had some people get crushed to death a couple of years ago at Christmas time. OSHA came in and cited them for a general duty clause on that particular incident. Combustible dust was a big issue under the general duty clause for OSHA. So even this one little sentence is quite significant as far as OSHA is concerned. Now, the history of the general duty clause. The reason that this is important is because these debates that were recorded in Congress in 1969 and 1970 supply documentation on the purpose and also limitations of the general duty clause. In our office, we have used the argument of, quote, intent, close quote, successfully against some general duty clause citations because OSHA has overreached in certain instances. They use the general duty clause to require the employer to act as an absolute insurer, and that certainly was not the intent of Congress. In the second session of Congress in 1970, that was the first time there was a mention of an employer's general duty to provide a safe workplace and protect the safety and health of employees. So the records of these debates show a real concern by the congressmen, the senators, and the representatives of potential abuse of the general duty clause. It could be interpreted in varying ways. So our point today, what Don and I are going to talk to you about, is for you to realize the concerns and dangers of abuse by OSHA, and using the general duty clause can be avoided by knowing this history. The purpose of the general duty clause really is to have employers focus on prevention. The programs we're going to talk about will begin to reveal to you how to recognize hazards in the workplace. And that's the purpose of the clause, how to recognize hazards in the workplace and to prevent hazards. So the focus is always on the hazard, not the accident, not the incident, not the injury. The focus is always on the hazard. That's under the general duty clause, that is the focus. Unlike specific regulations that will focus on the accident and how to abate a similar problem. Under the general duty clause, there's a focus on the overall hazard, and the employer then can determine how to prevent and cure that hazard. This clause is used when there is no specific regulation to address the hazard. For example, what I just mentioned, workplace violence and ergonomic problems. I've had compliance officers basically explain their use of the general duty clause like this. If it looks like a duck, walks like a duck, quacks like a duck, It's probably a duck. So when OSHA walks into your workplace, they see a sloppy workplace, poor housekeeping, electric cords hanging. They're already on notice that this is not a safe workplace. So if there's not a specific regulation, they're already thinking the general duty clause. I'll give you an example. There's not a specific regulation for killer whales. Can you imagine that? SeaWorld had a problem. They've had a problem off and on for the last few years. A killer whale is by definition dangerous. And there had been some incidents of trainers being either hurt or they had incidents where severe damage could have occurred dealing with the killer whales. Unfortunately, I think it was 2.5, maybe 3 years ago, a trainer was actually killed by a killer whale. The trainers thought that the killer whale was probably just playing with this person. Unfortunately, she was dragged to the bottom of the pool, and she didn't get released for about 5 minutes, and she drowned. So OSHA filed a citation against SeaWorld under the general duty clause for the death of the trainer. All right, so we'll talk about that in a little more detail. Let's move on from the legal perspective to discuss the elements of a general duty clause violation. There are 4 of them, and they're very clear. 1, the hazard was recognized. What does that mean? What does recognized mean? We'll talk about that in a little bit. 2, the employer failed to keep the workplace free of a hazard to which its employees were exposed. So question, what if you're in the construction industry? What if you're at a construction site where there are multiple employers, subcontractors, multiple employees? Who is your employee? And who's the exposing employer? Now that fact pattern right there could probably be a webinar that we may think about down the road, but we're not going to talk about that now. But that's why I emphasized the words early on, hazard and employees and exposure. Those are the important points. There has to be a feasible and useful method to correct the hazard. So even though you have a hazard, you recognize it, your employees are exposed to it, if there is no realistic way to correct the hazard, OSHA cannot cite you under the general duty clause. Finally, the hazard has to present a serious harm, serious physical harm or death to your employees. And we'll talk about that a little more later. Okay, so what is a hazard? That's the important word for me today. A hazard is an exposure to the risk of loss or injury. I love this. I got this out of a law dictionary. It is a danger lurking in a situation which may develop into an active agency of harm. You have to love that one. OSHA defines hazard as the potential of death or serious physical harm. So OSHA has to establish that this hazard or this lurking risk of injury was, quote, recognized. Remember that the hazard has to be recognized, and this is one of the limitations on OSHA's use of the general duty clause. The hazard must be recognized. It has to be able to be recognized. We're going to discuss what that means in a little more detail in a minute. Your employees, not the general public, not another company's employees, but your employees must be exposed to the hazard. Now, a little more detail. The hazard must be recognized. Well, how do you recognize a hazard? Well, employer recognition is one way, and that means that you know there is a hazard. That means evidence of statements made by management or supervisory personnel during or before an OSHA inspection. If you didn't think how you handled an OSHA inspection was important before today's seminar, you better know it now. What you tell OSHA personnel when they come out and take a look at your plant, what you tell them over the phone can and probably will be used in their analysis under a general duty clause violation. Other things like safety work rules, accident reports, workers' compensation data, that is significant. Workers' compensation claims, that tells you that you have a hazard. Industry recognition, that's right there. The even warnings on an equipment, insurance industry studies, government agencies. I would note NIOSH, NIOSH, the National Institute of Occupational Safety and Health. That was actually created by Congress when they did the Occupational Safety and Health Act, the OSHA Act. It's sort of like their scientific advisor. And then common sense recognition. I actually pulled this from the Compliance Officer Manual. This is what the people who come out and take a look at your facility have as their manual, and this is an example of a common sense recognition. So if somebody's dumping bricks 26 feet down onto an alleyway where you have workers down there working, that is a recognized hazard. Likely to cause death or serious physical harm. I'd like to say that that's obvious, but serious physical harm can be sometimes litigated. For example, if somebody has an injury to the arm, but they're still able to use the arm, is that serious physical harm or is that just mild physical harm? But at any rate, you'll see how that can be established by OSHA. Now let's talk quick about the use of the general duty clause. The only time OSHA really can use the general duty clause is when there is no specific regulation or standard that is applicable. However, you need to know that if a standard does not address all of the potential hazards, OSHA will many times use the general duty clause in conjunction with a citation for a specific hazard. Example, let's just say that powered industrial trucks don't have a requirement in the specific standards to wear seat belts, but your facility has a history of the forklifts tipping over. And if you as the employer don't require or equip the forklifts with seat belts, this could result in a general duty clause citation right along with a forklift citation under the specific standard. So I kind of wanted you to be aware of that. OSHA will many times use the general duty clause just when it has a very dangerous type of business. We see it quite often in emergency rescue operations where there's a complex hazard. What I mean by that, I'm going to go back to the construction industry. There would be an example of a standard that only partially covers construction employees that might be exposed to a collapse hazard. The construction standard might have requirements for reinforcing steel in the wall and columns and other vertical structures, but maybe it doesn't have a requirement in horizontal structures like the floor or a ceiling. So a failure to properly install reinforcing steel in a floor in accordance with industry standards or a structural drawing could result in a citation under the general duty clause, even though there is a specific standard for that type of activity. Okay, limitations on the use of the general duty clause. I want to emphasize that it is not intended to require absolute safety and health in the workplace. Employers are not required to be insurers for absolute safety and health. They must address a hazard and not the particular facts of an accident. All right. I'm going to turn this over to our certified safety specialist, Don Elswick, who currently is sitting in California, and he's going to talk to you about a couple of interesting case citations under the general duty clause and then some best practices to do in your company.
Okay, well, I appreciate your presentation, Carl, of the general duty clause. You did a great job with the history, how it's used, and some of the requirements. Now I want to talk to everyone about, okay, what does this mean to me? We're all challenged every day with multiple tasks, and we like to use past references to kind of predict future behavior and also talk about it. So we've got a couple of citations here that we're going to go through. By no means, both of these companies, I want to make sure everyone understands this was, as you look at their records, it's not to impute or say anything poor about their safety records. It's just for us to learn from. So if you look at the first citation we're going to look at, this was Bert Adams Disposal Incorporated. In particular, we wanted to look at, they had a maintenance shop where they were inspecting a vehicle, and with this citation, you will notice that OSHA brought in the general duty clause, but they also were able to bring in some other requirements on this too. So we had not only the general duty clause, but we had a few more citations. Lockout, tagout, they also discussed some of their medical. And if you look at the penalty, if you go in and add them all up, it was a little bit more serious than just the $3,500. But again, no standard for why this employee shouldn't be working there, and they were able to use that. Our next example is where OSHA used a consensus standard, and we've always heard, you know, OSHA will not fine you on consensus standard, their industry practices. Well, as you look at this from Century Foods, again, they pulled in the general duty clause, but also they were able to look at some of the other standards. This one also included some information on ladders, and they discussed with that the ANSI standard and cited that. So again, you know, just a couple of examples we wanted to go through. Well, what Carl and I would like to do is we've kind of talked to you about what I'll call what is it, you know, what are the requirements, but again, we want to talk about 3 separate programs that will help your safety program. And quite frankly, we know everyone is challenged to find employees, so we want to talk to you first about I2P2, or Injury and Illness Prevention Programs. I'm sure some of the people that are in the webinar are in areas where it's required, but we want to just talk through the requirements of that program. So the first thing I want to point out on this is the magnitude of the problem. And a lot of people have heard me talk about the burning platform. This is what...
I guess Don lost his connection, so I'm taking over. And now you're going to get to hear me talk without being prepared. So I2P2 is a program that's actually covered in at least 34 different states. It's a program that focuses on prevention, just as we talked about earlier. And you have 6 core elements in this. And every good safety program has these elements: management, leadership, worker participation, hazard identification and assessment, hazard prevention and control, education and training, program evaluation and improvement. That's the I2P2 program. Now, states that have implemented this program have evidence and data which shows that it reduces injury, saves employers money, and protects employers. So here are a couple of examples. Direct costs of injuries and illnesses. Many of you know who are on the webinar, because I know some of you, how to calculate the costs of injuries. It's way more significant than just the dollar amount that is paid in the injury. So the I2P2 program actually begins to save companies money. Here are some indirect costs that we would take a look at when we're trying to project for a client how much an injury actually costs. So it's wages not covered by workers' compensation, administrative time, headache, lost productivity. It can be 1.1 to 4.5 times the direct costs. And I think Commander Elswick is now back out of the water. Let's see if he's back online.
Yeah, thank you again, Carl. Sorry, everyone, I lost that. But again, as Carl was saying, I heard most of what he had, and I appreciate him picking it up. But we know the indirect causes, cost of injury and illnesses are high. I use the example, usually the medical costs are very high, but as we're looking at the entire safety, quality, productivity, and cost effectiveness, again, that safety piece and getting them medically ready is important, and that's significant. But as Carl said, almost in every injury I've reviewed, 5 times that cost is usually the cost of replacing them, the tribal knowledge that we go through to try to get someone up to date on that and going through that. So let's go ahead. Carl, if you can advance for me. Okay, so some of the hidden costs, again, of injuries, we can tell, you know, the magnitude throughout the U.S. is about $40 billion a year. This has been documented, not to mention the occupational illnesses and also new illnesses. So as we look at it, as I always say, we have reasons to modify the programs, but here's what we can tell you, and this is based again on research. What do the injury and illness programs, how do they work? Again, each workforce will transform the workplace health and safety culture. Again, we know employees want to feel part of the team. They want to feel they're making a difference. Again, that morale and communication is there. And let's just face it, any company wants its image to be very pure, pristine, and they do not want negative regulatory attention. It is, as I was often told, you need to delight the customer. Well, again, that name on whatever you're packaging or putting out is very important to that. And again, most companies have continuous improvement programs where they want to improve that. So again, how do they work? Carl and I are both big on, we're just not giving you data that we think. We like to go back to the research. And if you look at the graph that's in front of you, 231 companies were looked at in 2009. And if you go back to what I told you earlier about the safety, quality, productivity, and cost effectiveness of an injury and illness prevention program, you can see the productivity increase is 43%, which is the greatest increase, but also you've reduced cost, which again is just valuable to all companies. So in the summary of what we're doing here, do these programs work? Well, we want to tell you, based on our research, that 15 to 35% will reduce injuries. Now, is that immediate? Is it something you can walk out, you implement today, and go tomorrow? No, it takes time. It takes buy-in. It takes really your company to go through it. You know, the savings in workers' comp costs, we always talk about it, and Carl and I both enjoy, you know, working through workers' comp, but one day we'd like to do a different type of occupation and work more on the prevention side and really work for you. And we've already discussed the indirect cost on these injuries, so they're significant. Here's a small business success story we wanted to bring up. And in particular, we wanted you to look at the payroll. They did not reduce people. A lot of people will say, well, the way to gain is actually cut, and we know that's not true. If you look at their losses and their losses per $1,000 payroll, it dropped. And again, this is just one example, and there were several examples we could go to. So if you want to know who's using them, as Carl mentioned, I'm in a state that requires injury and illness prevention programs. That's California. Many states have voluntary. And again, we hope after this you realize there's financial incentives to go through that. So with that, Carl, I'll let you talk about some of the health and safety guidelines and finish us out.
The health and safety guidelines is a program that was, I guess, updated would be the way to put it. In November of 2015, OSHA presented a draft for public comment. It is very similar to the I2P2 program that Don talked about. I would recommend you go to the OSHA website and check this out. It's an excellent program. It has core elements. Each core element has action items for employers that lists examples of steps that you can take and that workers can take. This program was developed from experience OSHA had with some of their other programs, the Voluntary Protection Program, the Safety and Health Recognition Program. So this is a proactive approach to finding and fixing hazards. Very helpful when you're dealing with the general duty clause situation. Finally, if unfortunately you are presented with a general duty clause citation and you have done everything right, you have a written safety program, you train on this program, you follow some of the tips and guidelines in the Injury and Illness Prevention Program and the OSHA Safety and Health Program Management Guideline, but you have an employee who did something they weren't supposed to do. OSHA comes in, hits you a citation, let's say of $10,000 under the general duty clause. You can defend that citation. You have to have evidence that establishes that the employee was trained pursuant to a written safety program. I need to emphasize written. You have to establish then that the safety rules were adequately communicated. That means that it was communicated to them in a way they understand it. For example, if they're Hispanic and English is not their main language, then you have to communicate to them in Spanish. The last element is the employee has to be disciplined. And what I mean by that, and this isn't me saying it, this is the United States Supreme Court saying it, that the employer values safety with a history of discipline. So you're encouraging your employees by disciplining them when they don't follow written safety program. And in this particular case, if the employee did something they weren't supposed to do and they violated a written safety rule, you discipline them. That is an excellent defense to a general duty clause citation. So we're going to end how we started. You define your reality, or OSHA is going to define it for you. These are the points we talked about. You have to be proactive in safety matters, develop and practice a written safety program with regularly documented training. The management and employees both have to be committed to safety full-time, all the time. All right, well, I want to thank you, and I'm sure Don thanks you for your time in attending this webinar. If you have any questions or further information, give us a call. I'm going to turn it back over to Carrie to finish this out.
Thank you for taking the time to attend our webinar today. We hope you learned a lot. If you have any further questions, please contact either Don or Carl. All of their various contact information is shown on the screen. I want to announce that registration is now open at bugbylawyers.com for our next workers' compensation webinar on conducting workers' compensation claim investigations. And please keep your eyes open for the announcement of the third installment of our 2016 OSHA Webinar Series. Thank you again for your attendance.